So section 115, police exercising absolute care with everyone act. And you could probably guess by that flowery phrase that it's supposed to stand for something. And so the short title is the Peace Act of 2022. I think we talked about this a little bit at the last session about requiring de-escalation. And so let me just kind of go through this section. In short, it would require, I would say it standardizes 3 levels of first, police officers would be required to try and de-escalate confrontations with people before escalating to less lethal force. And then if less lethal force and other alternatives had been exhausted, then deadly force would be an option on the table. And we'll go back to our definitions of what these things are. And we talked about deadly force means force which a reasonable person would consider likely to cause death or serious bodily harm, including the discharge of a firearm, a maneuver that restricts blood or oxygen flow to the brain, including chokeholds, strangleholds, neck restraints, neck holds, and carotid artery restraints, and multiple discharges of an electronic control weapon. Multiple uses of a taser can be considered deadly force. Less lethal force is just a simplified version of that. It's defined as any degree of force that is not likely to cause death or serious bodily injury. All right, so not later than February 28th of 2023, the Attorney General would provide guidance to federal law enforcement on the types of less lethal force and deadly force that would be prohibited under this section, and offer guidance into how federal law enforcement officers can assess whether the use of force is appropriate and necessary, and how to use the least amount of force in interacting with certain at-risk individuals. Those include pregnant individuals. I'm not sure if we talked about in the qualified immunity discussion last week, a woman who was tased multiple times and sued the police officers only to be told that they had qualified immunity for that. Children and youth under 21 years of age. This can really be a traumatic thing for a child, as we talked about the pointing of a gun at them. And unless there is absolute necessity for it, that sort of thing would be prohibited. Don't point guns at kids. Don't point guns at anybody if you can avoid it, right? Elderly persons. We saw, many of us remember the video from the George Floyd protests last year, the elderly man in Buffalo, New York, who attempted to talk to some police officers and was shoved to the ground and lay there bleeding from his skull. Roman 4 is persons with mental, behavioral, physical disabilities or impairments. Unfortunately, to the extent that we use police as first responders to people who are having mental health issues, it is especially important that we offer additional training on ways that they can de-escalate those situations and not respond with force. Prone 5 is persons experiencing under the influence of drugs or alcohol, and again, people aren't making rational decisions. They're not in the right state of mind. It's always best to try and avoid escalating the situation. Also, for persons suffering from serious medical conditions and persons with limited English proficiency. Again, miscommunications lead to tragic accidents sometimes. And again, so this section would require that federal law enforcement be trained in how to avoid escalating actions with people in these situations. This section would also prohibit an offense to any charges of murder that the officer's use of force was inconsistent with these. So in the case of George Floyd's death, for example, if the officers are charged with murder, they would not be able to defend to say that officers' use of such force was inconsistent with the de-escalation provisions of the section. And then once again, this section would put the same, offer the same carrot, use the same carrot and stick approach to the states, requiring states to implement these same training procedures for state and local members of law enforcement, and once again withhold burn grants and cop grants beginning in the 2025 fiscal year if they did not have a law on the books that that met these standards. I just, as I've worked on this, I was thinking about it recently, where we saw that case in California, where there was a man having a mental health situation in a sort of Burlington coat factory, and the police went charging in there and shooting and killed some innocent girl in a dressing room because the first thing they jumped to was firing off their guns. And so it's really important to change that model of behavior and try and train them to higher, better standards. And so that brings us back to the title of this section, the Peace Act of 2022. I think, Mr. Chair, I think that concludes my testimony on section 115. I'd be happy to answer any questions.
Yes, I have a question. You had specifically mentioned discharging an electrical weapon multiple times. Is that correct so far? That was.
Yes. So that's included under the definition of deadly force. So yes, that could be considered deadly force.
Okay. My concern is kind of the specific situation of shoot a taser and it misses. Does that count as discharge under that? Is that a tally under there? And I have a follow-up after that too.
Use of tasers is not my specific area of expertise, but my understanding is that for the taser to work, like there's got to be something for the electricity to pass through. And so if you shoot it and it doesn't hit anything, I don't think the electricity goes through.
The electricity does not hit the person, but there is a firing of the weapon to shoot the pins out. So you're saying that you would not count that as a discharge under that definition. So the discharge must include actually electrocuting a person then.
Yeah, I think it says an actual discharge of multiple discharges of an electronic control weapon.
I think the term discharge could be interpreted to mean the firing of the pins even if no electricity is discharged, because it is a different definition of discharge in terms of like firing a weapon. So it might be worth changing that definition to specifically mention actually electrocuting a person to add clarity to that. And then the follow-up to that would be sometimes or if you discharge the electricity, so you electrocute a person and then they're complying at first, but then they stop complying, but they still have the pins in them. If you were to shock them again, that all of a sudden has now shifted from being less lethal to deadly force under that definition. Would that be correct?
Yes. And so we'll go back to B, subsection B, number 3, the prohibition on use of deadly force. So a federal law enforcement officer may not use deadly force against a person unless the form of deadly force used is necessary. So it would need to be necessary to shock the person multiple times another time as a last resort to prevent imminent or seriously bodily injury or death to the officer or another person. So if it's necessary, it would be necessary to prevent serious bodily injury. Then B is that that use of deadly force creates no substantial risk of injury to a third person. Shocking someone with a taser multiple times shouldn't harm any innocent bystanders. And then C, reasonable alternatives to the use of the form of deadly force have been exhausted. So if you tried it once and it didn't work, then you have exhausted the less lethal force alternative.